And we are back on the record in cause numbers 2016-0D02790 and 2021-0D03075, State of Texas versus Francisco Monares. After allowing counsel an opportunity to privately discuss the extension, I guess that was part of this plea and the recommendation from CCR2 drug court or DWI court, the plea agreement will then be modified for an 18-month extension. Your client is in agreement with that, Mr. Roman?
Yes, ma'am, he is.
Okay, so let's go ahead and get started now. So Mr. Monares, what we're going to do is handle the plea on the new case. And then once we get that taken care of, we can modify you with probation on the old case, okay?
Yes, Your Honor.
All right, so let's get started in cause number ending 3075. Mr. Monares, would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. You can put your hand down. Sir, will you state your name for the record?
Francisco Monares.
Mr. Monares, I have documents and I will be asking you questions about documents you may have reviewed with your attorney. In this case, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Monares, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, Your Honor.
Did you understand everything contained within that document?
Yes, Your Honor.
Mr. Roman, have you had more than 10 days to prepare a defense in this case?
Yes, ma'am.
And in terms, I don't recall if you had filed a motion to suppress. There's no outstanding motions. And if there are, you are waiving those at this time?
There are none pending, Your Honor.
Okay. So did you explain the plea papers to your client?
I did thoroughly.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, ma'am, I do.
Mr. Monares, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
And Mr. Roman, do you have any reason to believe your client is not presently competent to enter his plea?
No, ma'am, I don't.
Mr. Monares, have you ever been found incompetent by any court?
No, ma'am. No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
United States.
Okay, so the charge against you in this case is driving while intoxicated, third or more offense. To that charge, what is your plea, guilty or not guilty?
Guilty, Your Honor.
Are you making your plea freely and voluntarily?
Yes, Your Honor.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element the offense charged, a driving while intoxicated third or more, if at trial beyond a reasonable doubt. Judge, the defendant is pleading to a 5 years TDC probated for 5 years of adult probation with being screened and accepted into the DWI program with Judge Anchondo from County Criminal Law number 2, and other terms and conditions stated on the state's plea paperwork. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosure, and Exhibit 3 is the indictment.
Any objection, Mr. Roman?
No objections.
State's Exhibits 1, 2, and 3 are admitted. And is that your understanding of the plea agreement, Mr. Roman?
Yes, ma'am, it is.
Mr. Monares, is that your understanding of the plea agreement as well?
Yes, Your Honor.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is a one-page document entitled The Trial Court Certification of Your Right to Appeal. There's a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Monares, do you recall reviewing that document with your attorney and signing that document?
Yes, Your Honor.
Okay. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of driving while intoxicated, third or more offense, and I will assess your punishment pursuant to the plea agreement at 5 years confinement in the Texas Department of Criminal Justice Institutional Division that will be suspended for a period of 5 years of community supervision. There will be a $4,000 fine. However, $3,500 of that will be probated, which means that $500 is technically due. And as long as you are compliant on probation, they will not collect the rest of the fine. If you are not compliant at some point, they can always come in and collect the entirety of the $4,000 fine. 200 hours of community service. You are to participate in the CCR2 DWI court. Follow all conditions there. You also will be subject to TAP, urine and breath analysis, curfew, court costs, counseling. You are not to operate a motor vehicle. You may not operate a motor vehicle, period. You are to have the portable monitoring device that has both GPS capabilities and daily reporting. This sentence will run concurrent with cause number 2016-0D02790, for which you are being modified to be a participant in DWI court as well, with an 18-month extension. So that is different from the original plea papers, but understanding that the defendant is in agreement with that. In addition to that, there is 30 days confinement as a condition of your probation. Because you will be participating in DWI court, I'm going to require that you complete those immediately. So what that means, Mr. Roman, is although he will be released, considering it's a holiday this weekend, I'm going to have him turn himself in. We're going to have to do it this weekend. So he's going to have to turn himself in this Friday, April 15th at 8 p.m. and he will be released at 4 a.m. I don't have a problem doing that work release. And it will be consecutive, meaning, Mr. Monares, you will have to do that every day until the completion of the 30 days ACOP. Part of the consideration there, first of all, is because really, as your attorney, I think, mentioned off the record, you are getting a really good deal here because I am putting an eye to treatment. But I will be requesting reports from Judge Anchondo, and I'm telling you, you better be on track with that treatment, because if you are not, I'm going to bring you back in as violating your probation. Do you understand me, Mr. Monares? These were very, very serious driving facts on this new DWI. For you to have been on probation and you're going to stay on probation, that almost never happens here. So you're going to give me those 8 cop days right in the beginning. Again, I don't have a problem with work release. It is also more workable, I think, with the treatment plan to have you complete those days on the front end, because as you go through the different stages of treatment, it's not generally a good thing to find that you've made what I hope is going to be tremendous progress and turn your life around, and then find out you have to go to jail for 30 days. Right? You don't want to do that when everything's good. You kind of do it, take your lumps at the beginning. So, Mr. Monares, I don't want to receive one bad report from you, from Judge Anchondo on you. I will remember the circumstances of your probation, okay?
Yes,
So,
yes, Your Honor.
it's a tough program. Please use it to your benefit. So with that said, is there anything further, Mr. Roman or Ms. King?
Nothing further from the city, Your Honor.
I guess only, Your Honor, that Mr. Monatis pleads true to the revocation violations.
So we're just modifying him. So
Okay,
the motion,
okay, you're right.
the motion on Mr. Monatis's probation case, if there's still one, I think needs to be dismissed once we have the modifications file.
You're right. Okay, thank you.
Okay, so Carla, if you'll send those to me whenever they're ready, we'll get them squared away. Thank you very much. Good luck to you, Mr. Monares.
Thank you, Your Honor.
Thank you, Judge. May be released.
Yes, sir. Have a good day. Who's next?
Bottom of page 4, Valles.
So can we take care of the pleas and, oh, okay, no, they came on camera.
Thank you, Judge. It'll be quick, much quicker than.
That's what I thought thought this whole 3 o'clock slot was going to be, and everything has been as bumpy and messy as the weather outside. Son of a gun. Because we also have our interpreter here, right? Okay, so
Yes,
let's
Judge.
get started.
In cause number 2019-0D04292, State of Texas versus Daniel Valles. Announcement of council, please.
We're King for the state of Texas.
Veronica Lerma and Eduardo Lerma, Your Honor, on behalf of the defendant, we are ready.
And Mr. Valles is appearing from the jail annex. We are scheduled today for a status conference. And I thought we had outstanding, I thought there was going to be some kind of review that we were working on. There was some delay in that, but I think it hasn't happened yet, right? It's happening tomorrow.
Yes, Your Honor, we have a scheduled in-person inspection at the medical examiner's office at 10 a.m. tomorrow, and I have sent the details to.
Okay, there's some background noise. Got it. I thought I'd heard that. So we are, Ms. Lerma, were you going to say something in addition to that?
No, Judge, just that we're scheduled for tomorrow. We weren't able to do it before this hearing, but we did schedule it.
Okay, so how is that going to impact? Clearly, there's been a little bit of delay, and I think when we left our in-person hearing last time, I had indicated let's have, like a Friday deadline, and I was anticipating having everything wrapped up by this Friday on the motion on the Daubert hearing. So I don't have a problem giving you one more week if you need it, depending on what you see tomorrow. But I really want to make that a hard and fast deadline because I think if you all are going to submit anything written, it has to be done by next Friday. And I will schedule a status. Let me see, where are we? Ay, Dios mío, I'm losing track of the calendar. On April 26th.
Okay.
And what remains outstanding? Do we need to do this in person? So do I need to pick a different date? Because I'm anticipating this being just at the jail slot. Because at this point, once we get past the Daubert, I don't know what else is left. We need to get a trial date set.
And I think that's correct, Judge. I mean, I don't think we need an in-person hearing for whatever the outcome is tomorrow, unless it's something shocking. I don't think it would be on the testimony, and the court can give us its ruling.
Okay.
We will be happy to supplement based on whatever the finding is tomorrow.
Okay, so let's just have the deadline then be the 22nd for completion, everything submitted on the Daubert, on the two experts there. And then we'll come back on a status on April 26th at 3 p.m. Have your calendars all meshing well and figured out. So let's look for a date and let's just get it set at this point. Yeah, we're there. Okay.
Yes, Judge.
All right, guys. Thank you so much.
Thank you, Your Honor.
Thank you, Your Honor.
Unless you all have something else, we're good to go. See you on the 26th.
Thank you.
Thank you.
Take care.
I believe Ms. Garcia is here, Judge.
Let's take care of the interpreter really quickly. Who's the interpreter on?
On page 4, on Ruiz, Mario
Okay.
Ruiz.
Annex, if we could have Mario Ruiz, please. And we'll take care of Ms. Garcia and Mr. Ramirez right after that. All right. So can we start the interpretation function?
Yes, Judge.
Mm-hmm.
Mhm.
Add. Start typing her name. Gloria.
Hey, Judge.
Okay, so if you all will select the appropriate annex, if you'll select Spanish, please.
Yes, ma'am.
Missy Bobbin, is this yours?
Yes, Your Honor.
Okay, perfect. I can hear you. Thank you. Perfect. Okay, let's go ahead and call it.
In cause number 2022,
Mr.
Zero
Manafort,
D.
you need to select English, please. I can't hear you.
in cause number 2022-0D00154, State of Texas versus Luis Mario Ruiz. Announcement of council, please.
Roa King for the state of Texas.
Deborah Bobbin for Mr. Mario Ruiz, and we are ready, Your Honor.
MSC Bobbin, do you see your client appearing from the jail annex?
I do, Your Honor.
Thank you. And Mr. Reese is utilizing the assistance of a court interpreter. Ma'am, would you state your name for the record? Thank you, Ms. Noella. Mr. Reese, I'm going to be asking you some questions, so I need to swear you in. If you would, please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth? You can put your hand down, sir. Would you state your name for the record?
Mario Luis Puente.
Mr. Thank you, Mr. Ruiz. I'm going to be asking you questions about documents you may have reviewed with your attorney. The first of which is marked as State's Exhibit Number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Ruiz, do you recall reviewing State's Exhibit Number 1 with your attorney and signing that document?
Sí, recuerdo.
Did you understand everything contained within that document?
Sí, señora.
Missy Bobbin, have you had more than 10 days to prepare a defense in this case? Did she freeze? It looks like she's
Yeah, I
frozen.
thought it was me. Yeah, all right.
Yeah, I thought it was me too.
She's back.
Missy Bobbin, I think we lost you for a second. Have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
Okay, wonderful. And did you explain the plea papers to your client?
I did, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
Yes, Your Honor.
Mr. Ruiz, are you satisfied with your attorney's representation of you?
Sí, señora.
Missy Bobbin, do you have any reason to believe your client is not presently competent to enter a plea?
No, Your Honor.
Mr. Ruiz, have you ever been found incompetent by any court?
No, señora.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, señora.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a US citizen?
Sí, señora.
Where were you born?
Aquí en El Paso.
Okay, so the charge against you in this case is possession of a controlled substance and penalty group 1 in an amount less than 1 gram. To that charge, sir, what is your plea? Guilty or not guilty?
Culpable, señora.
Are you making your plea freely and voluntarily?
Sí, señora.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offense charge, possession of controlled substance, penalty group 1 less than 1 gram, beyond a reasonable doubt. The judge, the defendant is pleading to a 1244A of 180 days in El Paso County Detention Facility with any credit for time served and other terms and conditions stated on the state's plea paperwork. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosures, and Exhibit 3 is the indictment.
Any objection?
No objection, Your Honor.
States 1, 2, and 3 are admitted. Ms. Bobbin, is that your understanding of the plea agreement?
It is, Your Honor.
And Mr. Ruiz, is that your understanding as well?
Sí, señora.
Okay. Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion. and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Ruiz, do you recall reviewing the trial court certification with your attorney and signing that document?
Sí, recuerdo.
It was signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram. I will sentence you according to the plea agreement and in accordance with 1244A of the Texas Penal Code to 180 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. Is there anything further, Ms. Ibabin or Ms. King?
Nothing further from the state, Your Honor.
Nothing, defense from that. Thank you.
Thank you very much. Good luck to you, Mr. Ruiz. Let me ask, does anyone else need an interpreter? Do we know if anybody else needs an interpreter? If not, Ms. Moyola, thank you very much for your time.
Thank you.
All right. Who's next? And turn off the interpreter function.
Bottom of page 4, Judge.
Okay. Who is it?
In cause number 2018 0D01606, State of Texas versus Susana Victoriano. Announcement of counsel, please.
Roa King for the state of Texas.
Eric Meza for the defense, Judge.
Annex, if I could have Susana Victorino, thank you. All righty, so Ms. Victorino is appearing from the jail annex. We're scheduled for a revocation hearing, Mr. Mesa, but I know we're not here really for a revocation. And I know you guys want to keep her on probation, but I'm not going to keep her on probation. So have you all come to an agreement on time?
I believe we have, Judge, and I guess just for purposes of the record, we wanted to make that motion for probation and then, let the court do its thing.
Okay, go ahead.
Judge, you have made it clear that you've been leaning towards revoking her from probation and towards a jail sentence. And, the last thing we were asking the court to consider was the fact that Ms. Victorino was willing to be extended on probation, be modified, to be placed in DWI court or drug court or any other, program or terms that the court deems necessary. And the main reason for that was because she was in the process of helping her 25-year-old son adopt her 11-year-old son. And it's really important for her to be on the outside during that process, and that would require remaining on probation. And for those reasons, Judge, we were, going to ask the court to consider probation one last time, although we do understand that, the allegations and the violations have been laid out pretty clearly in this case.
Yeah. So no, Ms. King, do you have any input on that?
Your Honor, it's just that the state is not, is opposing to extension on the probation, and at this time, the rec is to TDC.
Mhm, mhm. That's where I am, Mr. Mesa. So that request is denied. I know Ms. Victorino's history. I can appreciate what you're telling me with the family situation, but again, never really did anything on probation. So we can, I don't know if have we had plea papers? Have we had plea papers circulated already?
Have we, Roa? I don't.
Your Honor, I did send the steps and waivers.
Okay. So we have not had them signed, Judge, but we can definitely get them signed and into the court immediately. And let me just,
Okay.
Obviously schedule a jail call with my client.
Sure. We're going to reset for 2 weeks at the jail slot, Myrna. So that'll be 4/12. It'll be 4/26, April 26th at 3 p.m. We can go ahead and just put that down for a plea of true. If something changes, Mr. Mesa.
Well, I'm sorry, could you repeat that date and time one more time?
April 26th at 3 p.m. It's our jail slot on a Tuesday.
Okay. I appreciate that, Judge. There's nothing further from us.
Thank you very much. Thank you, Ms. Victorino. Who's
Thank you.
next?
Staying on page 4, top of page 4, Judge.
Okay, go ahead.
In
Who is
cause
it?
number 2022 0D00793, State of Texas versus Alfredo Valentin Pizarro. Announcement of council, please.
Roa King for the state of Texas.
And Myrna Pages for Mr. Alfredo Pizarro, ready, Your Honor. Good afternoon.
Good afternoon. Annex, if I could have Mr. Pizarro, please. Alrighty, and Mr. Pizarro is appearing from the jail annex. We are scheduled for a bond hearing. Ms. Pages, you may proceed.
Thank you, Your Honor, if I may. Judge, so Mr. Pizarro is only 19 years old. He is from El Paso, Texas. I have been in communication with his mother. Her name is Darlene Pizarro, and she's very much involved in his life as well as all of his family, Judge. Mr. Pizarro, Your Honor, graduated from Horizon High School in 2020. He did about a year of college at Vista College for medical assistant and stopped going because the school had closed down. He is trying to go to EPCC to study psychology. He was working at All Generations as a caregiver for about 3 years full time. He does not have any children, Judge. I did speak to Mr. Pizarro recently, Your Honor, and he is currently taking some medications for mental health. He indicated that he has been given Prozac as well as Trelipdol, which I understand is a mood stabilizer for possible bipolar. I did request his medical records, Your Honor, from the jail. I'm also requesting that he be screened for Takumi, and Mr. Pizarro is willing to do that and also to obtain mental health services outside should the court reduce his bond. If the court does reduce his bond, Your Honor, he does have a place to stay. And I did confirm that, Your Honor, it would be with a family friend. Her name is Connie Espinosa. And I did call her this morning. I did confirm that he would be able to stay with her while these charges are pending. She resides alone. She does reside out in Ascension Street in Clint. And she's a lifetime family friend. So she is willing to take Mr. Pizarro. Your Honor, so we are asking, I don't believe that the court can grant a PR bond based on the charges, Judge, but we are asking for the court to reduce his bond. I believe that the family can come up with at least $700 cash. So we are asking for anywhere from $5,000 to $7,000 cash surety, Judge. I think that's all I have, Your Honor. Thank you.
All right, Ms. King.
Your Honor, the state respectfully opposes the bond. So there is a juvenile history. However, this is, I believe, the first adult. However, the facts of this case briefly involves 4 complaining witnesses. It is the defendant's sister, father, grandma, and grandfather. I'm waiting for the medical records to come in, even though there was an indication that there's some non-pros that is coming towards our office. And the police reported, it does say there was, the defendant did hit them with a branch. And he was at some point on top of his sister, and he did punch her as well. Just the facts surrounding this charge, the state opposes the bond.
Your Honor, if I may reply.
Yes, ma'am.
Thank you, Your Honor. So we do actually have 4 non-prosecution statements that I will be forwarding to Ms. King soon. I do believe, Judge, that this could have been a situation involving mental health. His family they've all signed non-prosecution statements. They are very much a part of his life, Your Honor. And he does have a good support system if this court is able to reduce his bond, Your Honor. And so I will be providing those non-prosecution statements to the state. And Mr. Pizarro is aware that he is not to be residing anywhere close to any of the complaining witnesses while these charges are pending, which is why we were able to get another address for him.
And his bond's $15,000, right? That's what his bond is at.
I believe it is, Judge. He has been in custody, I believe, for a little over 40 days now.
Okay, So I think the bond is appropriately set. So the request to reduce the bond is denied. Mr. Pizarro does not have future settings. So Myrna Hernandez, we need to put a trial track on his case 0793. And because I don't know if he'll be able to bond out, let's do a fairly quick trial track. I'm probably looking at something like September 30th. I'm not understanding this to be overly complicated, and I don't mean to rush you all, but I do think it's one that, if we're going to be either at a plea or a trial, I just assume get to it sooner than later, or if there's going to be some other disposition. So for now, that's what we're going to do, Ms. Pages. We'll do September 30th with a final hearing plea deadline on September 27th. We'll have our interim settings. If we've got non-process coming and, you all discuss it, we might have this figured out sooner than later. And if we don't, we'll have our trial date fairly soon.
Okay, thank you, Your Honor.
Okay, and if you have other issues to consider on a bond, just file your bond request.
Okay, thank you, Your Honor. May I be excused?
Yes, ma'am. Who's next? Thank you,
Okay.
Mr. Pizarro.
Second one on page 3, Judge.
Marissa, the reasons are nature and circumstances and future safety of the community. Thank you. All right, I'm sorry, who was that, Mr. Monaco?
Second one on page 3, Judge.
Okay,
In cause number 2021 0D02479, State of Texas versus Hugo Ibarragan Jr. Announcement of council, please.
Barbara King for the state of Texas.
Deborah Bobbin for Mr. Ibarwen, but he's not present yet.
Annex, if we could have, I'm gonna have trouble with this name.
It's coming right off.
Sure, Ibargan, is that how it is? Missy Bobbin, oh, that's gonna even be worse, Missy Bobbin and Mr. Ibar. Is that Mr. Ibargan? Is that, I'm sorry, sir, is that how you say your last name?
Ibarwen, yes, ma'am.
How do you say it?
Ibarwen?
Ibarwen, okay. All right. All right, and the defendant is present, appearing from the jail annex remotely. We are scheduled for a plea today. So Mr. Sir, I'm going to ask that you raise your right hand so I can swear you in so we can do your plea. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. You can put your hand down. I will ask you though, if you can speak just a little bit louder.
Yes, Your Honor.
Thank you very much. As I mentioned, we are scheduled, I'm sorry, would you say state your name for the record?
Hugo Ibarwen Jr.
Sir, I'm going to be asking you questions regarding your plea today. The first of which are going to be about documents you may have reviewed with your attorney. State's Exhibit number 1 are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Sir, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, Your Honor.
And did you understand everything contained within that document?
Yes, Your Honor.
Ms. Bobbin, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor.
I believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today.
Yes, Your Honor.
Sir, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
And Ms. Bobbin, do you have any reason to believe your client is not presently competent to enter a plea?
No, Your Honor.
Sir, have you ever been found incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
El Paso, Texas.
Okay. In this case, you were charged with the offense of terroristic threat against a peace officer or a judge. Sir, to that charge, what is your plea? Guilty or not guilty?
Guilty, Your Honor.
Are you making your plea freely and voluntarily?
Yes, Your Honor.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offense charged, terroristic threat against peace officer or judge beyond a reasonable doubt. Judge, the defendant is pleading to 2 years of deferred adult probation and other terms and conditions stated on the state's plea paperwork. And the state will also dismiss cause number 2021-0C02945. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosure, and Exhibit 3 is the indictment.
Any objection?
No objections, Your Honor.
Without objection, states Exhibits 1, 2, and 3 are admitted. And Ms. Bobbin, is that your understanding of the plea agreement?
It is, Your Honor.
And sir, was that your understanding of the plea agreement as well?
Yes, Your Honor.
Okay. Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Sir, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, Your Honor.
Finally, I'm going to ask you, the last document is the motion for deferred adjudication. Sir, do you recall reviewing the motion for deferred adjudication and signing that?
Yes, Your Honor.
Ms. Bobbin, have you explained to your client both the benefits and detriments of deferred adjudication?
I have, Your Honor.
Sir, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for this offense? Do you understand that?
Yes, Your Honor.
And are you asking the court to grant you deferred adjudication?
Yes, Your Honor.
Okay. I will find there is sufficient evidence to substantiate a finding of guilt in this case. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement and pursuant to 1244A of the Texas Penal Code for a period of 2 years. There will be a $3,000 fine. However, Missy Bobbin, any reason to think your client doesn't continue to be indigent?
He has remained in, I believe, 204 days. So yes, he continues to be indigent.
Okay, so I'm going to probate the entirety of the fine, sir. What that means is as long as you are compliant on probation, you won't owe the fine. At some point, you are not compliant with probation, they can collect that full $3,000, okay? There will be 200 hours of community service, screen for TAP, urine and breath analysis, curfew, court costs. You are to possess no weapons or ammunition. You have no offensive contact with the complainants. And then there will be a dismissal forthcoming in cause number 2021-0C02945. That is a misdemeanor, so it goes to the misdemeanor court. Is there anything further, Missy Bobbin or Miss King?
Nothing further. Your Honor.
Nothing further from the defense, Your Honor.
Thank you very much. Good luck to you, sir.
Thank you, Your Honor. Here, sir.
All right, so David Munoz.
Yes, Judge, bottom of page 3.
Annex, if I can have David Munoz, please.
Yes, no, please come in.
Thank you.
Good afternoon, Judge.
Hey, Mr. Stevens. Mr.
are
Munoz, is
you?
that you?
Yes, ma'am.
Okay.
Yes, Your Honor.
Thank you, Mr. Stevens. Go ahead, Mr. Monaco.
In cause number 2021-0D01363, State of Texas versus David Munoz. Announcement of council, please.
Robert King for the state of Texas.
Brent Stevens for Mr. Munoz. We're ready, Your Honor.
And Mr. Munoz is appearing from the jail annex. We are scheduled for both a probation status and a bond hearing. Mr. Stevens, you may proceed.
Thank you, Your Honor. Your Honor, Mr. Munoz pled in February, I think of the 25th or 15th, right around the middle of February, to a state jail felony, which was a enhanced shoplifting, and it was 2 years deferred. He's being held right now on a bench warrant for that case with no bond. And the allegations that are in the motion to adjudicate are, one is that in the beginning of March, he was arrested for public intoxication for alcohol. And then also in March, he was charged with criminal trespass. The criminal trespass is, I haven't been able to see the police reports yet, but based on what I know, I'm pretty certain there's not going to be any type of burglary or theft or damage to. It was just a matter of living in a vacant home is what it's going to boil down to. So we're asking that Mr. Munoz be allowed to be released, Your Honor. He's been in jail now for 19 days on the bench warrant. He's 52. He does have a place to live with his mother. He can go live with her for a while until he finds a place to live. He had previously been living in an RV, but lost the RV because the owner needed it back due to his own family problems. So Mr. Munoz told me he can live with his mother for a while until he finds a place to live. He does have a job. He's an independent contractor as a diesel tech. And so he has a couple of companies that hire him on a regular basis. And he works part-time. He probably could easily find full-time employment. And in fact, based on my conversations with David, I know that he's trying to do that, and he's trying to get his life in order. He does have one daughter that he helps support with child support. And there is a 1622 in this case, Judge. I won't go through the contents due to the YouTube, but I know it's available to the court. He's not eligible for a 17.032 because of, like old cases. But I still believe a PR bond would be appropriate for him. He has made great strides in overcoming drug abuse in the recent past. He has a problem with alcohol now that he wants to work on, Judge. So he hasn't given up on himself. And so we're asking the court to release him to probation.
All right, Ms. King.
Your Honor, the state opposes for any bond reduction based on just the criminal history alone. We do have a 2020 theft of property between $2,500 with 2 or more previous conviction. We have an assault causes bodily injury family member in December 2019. That was a convicted lesser included charge. We also have another theft with 2 or more previous conviction back in 2018, and I believe that was 4 charges. We have a possession controlled substance, PG1 less than 1 gram in 2017. We have a conviction, another theft of property with 2 or more previous conviction in 2017. I can go on and on. We also have driving while intoxicated, 3rd or more in 2014. Judge, he was placed on probation on this case on February 15, 2022. And he managed to pick up within 2 weeks or so a public intoxication and a burglary of a habitation that is currently in screening in our office.
May I respond very quickly, Judge? Just very shortly. I do not believe it's going to be a burglary. I believe it's a criminal trespass of a habitation. That's what he was booked on at the jail. So I do not believe it's going to be a burglary, but I mean, I'm not the one that makes that decision in the final analysis.
So, yeah, he's got an extensive criminal history. He's on deferred, right? How did he get deferred? That's because he's got plenty of, he's got a few TDC trips, right? Yes. And then do you show, I'm showing, just now that we have this PSR system and everything, that he also picked up a shoplifting in 2020 in Hobbs, New Mexico. Is that him? Do you see that on your wrap?
Your Honor, I do not, unless I missed it.
So I know those predate his plea, but yeah, no. So he's entitled to a bond, Mr. Stevens. It's not gonna be a bond. He's gonna make, it's gonna be 100,000 cash surety bond. So that will be the order on the bond. We do need, though, another setting. So we'll do a status in 30 days unless you want to go Revo route. Really, we just need to, it's going to have to be a compelling case, Mr. Stevens, if you're telling, if you're going to go probably some treatment route or something like that, because I don't think I'm there.
Okay, Judge. I'll talk to Ms. King and then speak to my client, and we'll get back to the court if we have any types of agreements.
See you in 30 days. Thank you very much.
Thank you, Judge.
Okay, so Mr. Ramirez, who is still pending? Who else do we have outstanding?
I believe that was it, Judge. Just Ms. Garcia keeps in and out. I guess she's still having technical problems.
Okay, so let's get off YouTube. If we're done with the annex, thank you very, very much.
Thank you, Your Honor.
Okay.